today is part one of the two-part training. Together for both trainings, you can receive 4 CLE credits. We're going to focus today on why restorative justice, principles, values, and practices, as well as RJ and the intersection with RJ and the criminal legal system. Part 2 of the training, as I mentioned earlier, will be held on October 29th. That's Thursday from 2:30 until 4, and we'll focus on implementation. And in particular, we're very, very excited to offer a panel of experts from across the state in integrating restorative justice into diversion programs. Our experts are going to include Erin Cordell, Kirsta Britton, Sarah Erickson, Luke Yoder, and Chris Brown-Haugen. In 2016, a report of the first ever national survey of victims' views on safety and justice was published. The survey of victims' views on crime and safety and justice revealed perhaps some surprising information. First, 1 in 4 people have been crime victims in the past 10 years, and half of those people were victims of violent crimes. The strongest predictor, it turns out, of victimization is actually prior victimization. Second, people of color are 15% more likely to be victims of crime. Further, young people and people in communities that have low-income communities, are also more apt to be victims of crime. Third, more than half of violent crimes go unreported. That's a total of 54% of crimes that go unreported. And the top 2 reasons given by the survey respondents for not reporting crime were 1, the police wouldn't do anything about it, and 2, the prosecution and courts would not help. So in short, many victims do not feel well served with the criminal legal system. Finally, the overwhelming majority of crime victims, including victims of violent crime, believe the criminal legal system relies too heavily on incarceration. They strongly prefer investments in treatment and prevention to more spending on prisons and jails. Some of the most popular views among the respondents were to increase investments in school and education, crime prevention and treatment, and alternatives to incarceration, as well as options to hold people accountable beyond prison. More and more research from neuroscience and medical doctors and beyond recognize the important role trauma plays in our lives. 2/3 of people in our community suffer from trauma day in and day out. As we are operating within the criminal legal system, we work with people who suffer with direct trauma. Hurt people, it turns out, often hurt people. And when a person suffers from trauma, they aren't capable of showing up as their best self. All of this leads to the conclusion that we need to do more to support crime victims and survivors and to help aid in their healing journey around trauma.
All right, so as many of you know, the United States incarcerates more people than any other nation in the world. Currently, there are 2.2 million people in our country's jails and prisons. And mass incarceration has not affected all people equally. People of color are 37% of our population, but they're 67% of our prison population. As you can see from the slide in front of you, which shows lifetime likelihood of imprisonment, for all men, there's a 1 in 9 chance of ending up in prison. However, for white men, it's a 1 in 17 chance, Black men 1 in 3, and Latino men 1 in 6. A similar disparity is seen with women. For all women, there's a 1 in 56 chance of ending up in prison. White women have a 1 in 111 chance, Black women a 1 in 18, and Latino women a 1 in 45. So why are we talking about mass incarceration at a training about restorative justice and diversion? Quite simply because our current model really isn't working. There's been a 500% increase in incarceration rates since the 1980s, without a significant impact on crime rates. Our communities are not safer, recidivism is not lower, victims are still not given a strong voice in the process and are often therefore not satisfied with the outcomes, and our system is growing more and more expensive. Restorative justice is an opportunity to do justice differently, to get better results for everyone involved. So what could this model look like? Research indicates that crime victims value meaningful accountability above all else. So what is meaningful accountability? What do we mean when we say that? We mean deeply listening to the harm that was caused, acknowledging and owning your behavior, repairing the harm that was caused to both the victim and the community, and taking steps to ensure that this crime and this behavior doesn't happen again. And we would submit that it's often more difficult and tougher to sit face to face with a person that you've harmed, to take meaningful accountability and commit to tangible steps to repair the harm, than it is oftentimes to serve out a passive sentence in jail. Restorative justice offers benefits to everyone who's involved in the process, to victims, to defendants, and to the community. For victims, it offers the opportunity to be empowered, to tell your story, to have your questions answered, to be at the central process in the justice system. And thus, victims end up more satisfied when they go through a restorative justice process because of their centralized voice and ability to have a say in what happens. For defendants, they get to hear the impact of their behavior and their crime directly from the victim and from the community. This results in increased empathy, and as a result, greater behavior change. Defendants also are reintegrated back into the community with skills and awareness to prevent future crime and similar behavior. The community is also empowered and engaged to participate in the handling of a criminal justice case. They receive the benefits also of lower recidivism and greater public safety. And there's also a cost savings.
So being a parent has really forced me to consider what motivates changed behavior. How do we motivate people to change their behavior in alignment with our values? The fundamental underlying hypothesis of restorative practices is that human beings are happier, more cooperative, and productive, and more likely to make positive changes in their behavior when those in positions of authority do things with them rather than to them or for them. This diagram of the social discipline window shows 4 basic approaches to maintaining social norms and behavioral boundaries. On the one side, you'll see a spectrum of low to high control, and on the bottom axis, you'll see a spectrum of low to high support. The restorative domain combines both high support and high control or limit setting and discipline. And it's characterized, the restorative paradigm is characterized by doing things with people rather than to them or for them. And given many misconceptions within the criminal legal system around restorative justice, I want to be absolutely clear that restorative justice is not permissive. Okay, so we're come to our first breakout session, and we need to quickly make an adjustment with our breakout rooms for a second, so please bear with me. Okay. Thank you for standing by. I appreciate your patience while we figure out all the logistics with the technology. Okay, so I'm gonna slow roll this so Dorinda has a little bit more time. But essentially, what we're gonna do is we're gonna move into breakout rooms. Dorinda, you're gonna have to give me back some control because I now can't share my screen. Will you make me the co-host if possible? So what we're going to do with our breakout rooms, we're really excited. And if you're getting frustrated with us, I understand. You're more than welcome to look in that workbook. We have a ton of multiple choice questions that follow along with the materials. So you can use those if you need to fill some time. In addition, what we're going to do is we're going to put people in breakout rooms. We're going to try to do 3 breakout rooms total. In this first breakout room, we're going to pair you up, and we're going to invite each pair of people to spend about 6 minutes total, so 3 minutes per person, answering the question that was on the screen before I lost power and control. There we go. And here it is. And it's also, this question is also outlined in the workbook. So if you don't have access to the screen, once we put you into the breakout rooms, go ahead and look in that workbook. I can get you the page number real quick. But let's see. There's a little bit of space. It's page 5 in the workbook. Reflection question number 1 at the bottom with a little bit of space. For you to start thinking about it while Dorinda puts us into the different breakout rooms. When you're done with the breakout room, after the 6 minutes are over, so it'll have a little clock at the top, and I'll give you about 60-minute warning when you're about to get put back into the main room. And then we'll all show back up together, hopefully. So Dorinda, when you're ready, go ahead and put people in the breakout rooms. Is a set of principles, values, and practices that support people's healing, growth, and transformation by cultivating and personal and used as an umbrella word to encompass many different things these days, some of which are restorative and some of which are not. 2 guiding questions while creating, implementing, and running a restorative justice program are 1, what is my intention? And 2, is this decision grounded in restorative values? Often within the context of crime, restorative justice is a voluntary process that supports defendants to take accountability for their behaviors and actions. Formal RJ processes for crime include voluntary facilitated conferences or dialogues, ideally involving the people most impacted by the crime. That includes the defendant, the crime victim or survivor, and their support people. And sometimes it includes community members as well. Together, they discuss what happened, the impact of what happened, as well as how best to repair that harm. Crime victims do not have to participate, and in fact, they should never, ever be forced to participate. When victims do participate, however, the opportunity for healing greatly increases for both people involved. And the chance of recidivism also greatly decreases because of that connection, that relationship that is transformed between the person who caused the harm, the responsible person, as well as the person who is harmed. Finally, I want to note that RJ is actually the most common form of justice over the history of humankind. It was displaced by a legal system that allowed a royal crown to collect restitution as a proxy for actual victims. So the state or the crown was the one who was receiving the money, the restitution for the victims. So if the 2 guiding questions for restorative justice are, what is my intention and how does this align with restorative values, then we need to know what those restorative values are. This slide represents a collection of restorative values. There are not all of them necessarily, but these are ones that I have started to collect over the years. And some of the ones that are really important to me personally include respect, personal accountability, confidentiality, repair, reintegration, and my favorite, I think the one that I'm most drawn to right now is recognizing the interconnectedness between us all. So conflict is inevitable. It's part of being a human. But instead of looking at conflict as something negative, perhaps we can look at conflict as an opportunity to learn, grow, and transform. So three central questions the criminal system asks and focuses on are: what law was broken? Who broke it? How do we punish them? In juxtaposition, restorative justice asks what harm was done and to whom, what needs have arisen based on that harm, And whose obligation is it to meet those needs? Another way I like to say this is, instead of focusing on blame, shame, and punishment, let's focus on accountability, repair, and healing. Another point I want to make real quickly is how the criminal system often focuses on the defendant and holding the defendant accountable and potentially punishing the defendant. But restorative justice offers us a little bit more, because it can allow space to focus on both the defendant and making sure that they take accountability and repair the harm, as well as the crime victim or survivor. This is an opportunity for us to really support crime victims and make sure that they're getting what they need as well. Because restorative justice is grounded in values rather than a specific process, program, or curriculum, many restorative justice practices exist. To some, this proves maddening. To others, this is the beauty of restorative justice. The beauty of restorative justice is that it is adaptable to any circumstance, any challenge, any harm. We are limited only by our imagination, using restorative values as guardrails to guide that imagination. And I'll admit, as a lawyer, I'm pretty inclined to be dogmatic and to draw clear boxes and try to understand things in very logical way, right? But that is really challenged with restorative practices, which is something that I at first was really resistant to and now have grown to really appreciate and love. When I first was involved in RJ, I thought that there was only one process for RJ, and I thought it was high impact victim offender dialogue. And I have since learned that there are so many more practices and so many beautiful things that restorative justice can offer. But the one benefit of RJ that I think, and this flexibility, this adaptability of it, is that it can be adapted to any community's needs. And this is something we hear, Chris and I hear a lot when we talk to DA's offices or RJ programs across the state, is you can't just take something that's on the Front Range and put it somewhere on the Western Slope, or what's happening working in Denver doesn't work in a rural community. And that can be absolutely true. We need to adapt restorative justice practices to meet each individual community's needs. And I think that that is one of the, like I said, that's one of the huge benefits of this. So by way of an example, some of the processes that I'm familiar with in Colorado Diversion include restorative accountability circles, restorative questionnaires and conversations, and thematic programs like rethinking substances or rethinking drinking. Some of the more formal processes that are used in diversion and as well in sentencing and corrections include community group conferencing and high impact dialogues or high impact victim offender dialogues. So this leads to the question, which model is best? And I want to just offer that from my perspective as a restorative justice practitioner, having worked with crime victims and survivors, I would submit that the best RJ model depends upon what the victim or survivor's needs are, what they want out of the process. And then as a public defender, I really appreciate restorative justice being used in diversion. And anytime we can avoid mixing retributive values with restorative values, because I think that leads to mixed messaging about the way we want people to act and behave in the world.
All right, so we are going to do another breakout room, and we're going to ask you to be a little bit vulnerable for this one. So be prepared for that. We're going to be putting you into groups of 3 again. You'll have 5 minutes a person, so 15 minutes total. And we're going to ask you to think of a time when you harmed another person. We're going to ask you to think about how you took accountability and repaired that harm, if you did in fact take accountability and repair it. And then to make that connection between that personal experience and referring cases to restorative justice. So how does that personal experience inform your thinking on referring cases to restorative justice. I want to just reiterate one thing Liz said. Please do remember, conflict between humans is inevitable, so we're not here to judge. It's how we handle conflict that matters. So enjoy, be vulnerable, and we'll see you in 15 minutes.
Okay. So, Dorinda, do we have everyone back? Yeah?
Not yet. Wait about 13 more seconds.
Okay, sounds good. Thank you. I appreciate that help, Dorinda.
And that was really cool. Like, there's lots of amazing people on here. Oh my goodness.
Wonderful. I'm so glad.
All right, everybody should be back now.
Awesome. Thank you. Okay, well, welcome back from the second breakout. Hopefully you're enjoying these breakouts. We're trying to get things a little different. So let's see. Now we are into restorative justice in Colorado's criminal legal system and the intersection between those two. So RJ can be used in any type of conflict and thus in any type of criminal case. It can be used in adults cases and juvenile cases, petty offenses, misdemeanors, felonies, even violent felony. And I've even worked on using restorative justice in a capital case. That being said, not all cases are appropriate for diversion, and that is our focus today. So we'll discuss on day 2 a little bit more about case selection and what I guess I'd like for you to encourage you to think about today is, rather than thinking about whether or not a case is appropriate for restorative justice, instead think about whether or not the people involved in that case, whether the defendant and the crime victim or survivor, would be appropriate for restorative justice, whether or not this might be something that would be a benefit to either of them. So RJ can be integrated into any stage of the criminal legal system, from police to prosecutors, sentencing in court, as well as in corrections, including community corrections and parole. The restorative justice practices at each of these stages along the continuum may look different depending on what we're trying to accomplish. Back to those 2 questions: what is your intention, and is this grounded in restorative values? With different considerations, advantages and challenges at each point of this system, there are different laws that apply and different just logistical challenges that may arise. So it's important to think about it very much as each point along the continuum to determine what rights are at play, what other issues might come up, challenges with the facilitation, things like that. Okay, so I also just want to quickly note that there are 3 criminal legal systems essentially in any given state. So Colorado we have the municipal level of the criminal legal system. We have the state level of the criminal legal system, and then we have the federal level. And all 3 of those are suitable for restorative justice. There's no reason why we cannot be incorporating restorative justice into each of those types of criminal legal systems. Finally, in honoring victims, crime victims and survivors, I want to mention 2 additional things. First, we encourage you to think about all the ways in which your community can integrate restorative justice. All of the different ways, not all the points along this criminal continuum, but all the points in which community interventions occur within your community. So in restorative practices in schools, it's often talked about the best way, most effective way to do program implementation is about a whole school implementation strategy. So I would promote, or I would submit that perhaps we should be taking a whole community approach to restorative justice within our communities, within our legal system, within every part of our life, frankly. The more we integrate restorative justice into the various points along the continuum, the more responsive we can be to victims and survivors, and I'll offer them as many opportunities to participate in restorative justice as possible. And sort of going along with that piece earlier about hurt people, when we have less trauma, then we have less hurt people. The second piece I wanted to offer about victims is that considering that more than 50%, 54% to be precise, of victims do not report crimes, I just want to quickly note that people who are not engaging the criminal legal system are still figuring out ways to hold each other accountable outside of the criminal legal system. In the last 30 years, interpersonal violence survivors have really led a movement to integrate restorative practices into accountability and support processes within the community. And they're calling that transformative justice. So on this screen, it says informal, but really what I'm trying to represent with this diagram is that often crime that is not reported is still maybe going through a restorative process like transformative justice. Okay, so now moving specifically to diversionary models. One thing I've encountered doing work on the State Restorative Justice Council is there's a lot of confusion about what diversion means. So colloquially, diversion is known as any alternative to prosecution, any off-ramp from the criminal legal system without a conviction. And so that can happen in law enforcement, with police. It can happen with prosecutors being the gatekeeper, essentially. And to make it even more confusing for non-criminal system actors, and to make it more confusing for them, diversion programs are often also run through probation departments. So the thing that is different, though, for lawyers, especially Colorado lawyers, is that diversion may mean something very specific to them. It may be referring to the diversion statute, the adult diversion statute in Colorado's criminal code for pretrial diversion. It may refer to an attorney. An attorney may believe that diversion, or may talk about diversion as being the DA's very specific RJ program or diversion program. So just be careful when you're using diversion to make sure that everyone is on the same page as to what you mean. So this diagram illustrates some of those prosecution diversionary models commonly used in Colorado. And these are the models that we're going to be focusing on with this training. And RJ can be integrated into any of these diversionary models, as well as other jurisdictional unique creations within the legal process that fall within the general definition of diversion. So this is a map of Colorado, as you probably all recognize, divided up by the judicial districts. In June 2019, Dr. Shannon Sleva was, she published a report. She's a professor of social work at DU. And she published a report for the Colorado State Restorative Justice Council entitled The State of Restorative Justice in Colorado. Basically, it was a survey identifying what RJ practices were happening across the state so that the RJ Council could have a better idea of how it wanted to influence the expansion of restorative justice. 11 of the 22 judicial districts, half of the DA's offices, reported offering some sort of RJ programming, whether that's in-house within the DA's office or a partnership between the DA's office and a community-based restorative justice organization. So that's pretty exciting that half of our state, it has restorative justice programs associated with the DA's office. Similarly, 10 out of the 22 probation departments in the state also have restorative justice programming by their own reports. So I just wanted to name this because, like I alluded to a little bit ago, restorative justice diversion programs can be happening within a probation department. And actually the state adult diversion statute contemplates that happening. Finally, it's also really important to note that there are restorative justice facilitators who are willing to travel anywhere in the state to facilitate a case. So this is sort of like that transformative justice stuff we just briefly talked about. RJ is being used independently of the criminal legal system in Colorado, with victims and survivors contacting restorative justice practitioners privately to facilitate cases outside of the legal system.
Okay, so now we're going to talk about some legal considerations for when you are bringing restorative justice into the criminal legal system. Just as a note, in your workbook, there is a page in the appendices, I believe, that lists all of the relevant RJ statutes in Colorado. So if you get a chance to kind of look those over, it's interesting to see, you know, the different statutes that are on the books. It's on page 16. Thank you, Liz. So the first thing we want to talk about is what's called net widening. As we all know, prosecutors have an obligation not to prosecute cases that are not supported by probable cause. And what this means is that these cases also should not be referred to restorative justice. Only cases that the DA intends to prosecute are those that should be referred to restorative justice. And while this might seem obvious, I think it's also a temptation, as I've seen with our own program, because sometimes you have a case where maybe your evidence is thin, you're pretty sure that the defendant is implicated in some way, and you think, well, I'm just gonna refer to restorative justice because then at least there's some intervention. However, if there wasn't that RJ program, you would be dismissing the case. And you need to do that also even if you have these restorative justice or diversionary type programs. It's unethical to refer cases, obviously, that don't have probable cause to, that you wouldn't have prosecuted in the first place. Next thing we want to talk about is voluntariness. So you can't force anyone to participate in restorative justice. You can't force victims and you can't force defendants. It really defeats, obviously, the purpose of the program, and also it would be unethical. So restorative justice is only going to work if you have a defendant who's open to the process, someone who's willing and wanting to take accountability and wanting to work on repairing that harm. One of the things that Liz and I have seen as we've gone around the state and talked to different programs is that oftentimes, you know, we want to increase people want to increase the use of restorative justice, so it can be added sort of as a term of diversion. You know, we've got someone who's doing community service, substance abuse, treatment, and restorative justice. And that's fine if when you assess the person, they want to participate, they have a willingness to participate. But if it's put on as an obligation to participate against what the person wants to do, then the process is not going to work. It won't be successful. Next, confidentiality. As I'm sure many of you know, confidentiality is essential to creating a safe space for restorative justice and ensuring that the process is authentic. If it's not confidential, participants are not likely to be fully honest. Defense counsel is not likely to encourage clients to participate because of a fear that what they say might be used against them in some way. And again, the DA shouldn't need these statements to be used because you're only referring cases that you can prove without the statements in the first place. The pretrial diversion statute does provide some confidentiality protections. If a defendant has a statement of facts that they write as, you know, going into the diversionary program, it does state that it can only be used as impeachment if a defendant ends up failing out of diversion and taking that case to trial. But beyond the statutory language, in order for a program really to be successful, there needs to be additional confidentiality provisions. So what we would actually encourage is for individual DA's offices and programs to develop confidentiality provisions to protect the restorative justice process, to ensure that it's a safe space, and so that an authentic process can take place. Another important legal consideration is the right to counsel. Obviously, it's important that a participant is ensured the right to counsel and understands any legal consequences before they were to admit any sort of responsibility or take accountability. For post-file diversion cases, this usually isn't a problem. Once a case is filed, defendants usually are informed of their right to counsel. They have time to seek counsel, and they understand how that process works. The area where it's a little bit more gray and where there's potential issues are pretrial diversion cases. Oftentimes with pretrial programs, a person is diverted so quickly that it's oftentimes before they really understand that they had the right to consult with counsel. And, you know, we want to encourage the sort of the early diversion of cases, but just important to remember that when you are assessing a person for restorative justice or even for diversion, having some sort of, if they're writing a statement of facts, if they're taking accountability for restorative justice, we need to be really careful that we are making sure that people are advised of the right to consult with counsel and that they understand what the legal consequences are for taking accountability. It also kind of dovetails back into that confidentiality that we were just talking about and illustrates how important it is, because if there are those confidentiality protections that are protecting the process, then there's more assurance to the person that what they're saying is protected as a safe space. We do want to mention a couple of statutory requirements. So if there are situations of court-ordered restorative justice, you probably would see this more as part of a plea agreement or in sentencing. If the court is ordering a person to participate in restorative justice, there are certain cases where they are not allowed to order that. So in cases of, there's a sex offense case, domestic violence, stalking, and protection order violations, those 4 categories, the court is not allowed to order restorative justice in those cases. Similarly, but a little bit different, we see limitations for state-funded diversion programs as well, in terms of limitations on when restorative justice can be used. So in that statute, obviously, as we've discussed, there is the ability to use restorative justice in state-funded diversion. However, it also states that for those diversion cases, you can't, for domestic violence cases, the person has to participate in an evaluation. The DA then has to look at that evaluation and determine that they still want to refer the case before diversion could be used. Same thing with sex offenses, they have to do an SO evaluation and read the results of that evaluation before that you can divert with state-funded diversion. Sex offense cases, and then there's also certain enumerated sex offenses that are just point blank not allowed to be diverted under state-funded diversion. And then finally, victims' rights in the VRA. So there is a statute that's listed again in that workbook that the DAs do have to inform victims about the possibility of restorative justice. This includes both VRA cases and non-VRA cases. Obviously, as I'm sure all of you already do, it's important to treat all victims with dignity and respect, even those who are not victims of a VRA crime. And part of treating victims with respect when we're talking about restorative justice is really making sure that they don't feel any sort of obligation or pressure or intimidation to participate in a restorative justice process. We don't want them feeling like, well, if you don't agree to this, then the defendant's going to have such and such happen to them. It needs to be an entirely voluntary process, devoid of any sort of pressure, anything like that. And one of the ways that we can work to make sure that victims don't feel that pressure is by making sure that we have lots of options for them, as Liz mentioned earlier. So being able to physically participate, but also options to write a letter or to have a surrogate participate on their behalf, or to speak with someone and do a victim impact statement. So there's lots of opportunities of different ways the victims can be involved in restorative justice, and it's just important to make sure they understand all those ways and don't feel any sort of pressure at any point to participate. All right, so I'm going to do another breakout room. And this question, so we're going to give you 12 minutes total, again, breaking into groups of 3. You'll have 4 minutes a person. And we just want you to look at the cases that you're currently working on and thinking about which ones might be appropriate for restorative justice. You will be put into a group shortly. And it's on page 10.
So it's just you.
So we just wanted to say for the last few minutes, we wanted to thank everyone for being here. We really appreciate it. As you hopefully know and are already planning, day 2 of this training is going to be on October 29th from 2:30 to 4. And that's going to be focused a lot more on specific implementation of RJ into diversion programs. And we'll include that panel that Liz mentioned earlier. We appreciate all the questions that were sent to us during your registration, and we are trying to address that today or in the second part of the training. So if you asked a question that was not addressed today, just know that we will be getting to that in part 2. If other questions came up, feel free to reach out and let us know. And we'll just remain on here until 1:30. I think we're going to be about 5 minutes early when we're done. And then finally, just wanted to let you know that we are going to be emailing out a short survey after both today's presentation and on the 29th after that presentation. So if you have a moment to just give us some quick feedback, we'd really appreciate it and find it useful. So if anyone has any questions, feel free to put those either in the chat or we can now, and we can address them. If not, thank you so much, and have a good rest of your day.
Yeah, and thank you so much for all the amazing work you guys are doing across the state of Colorado. And if anyone has questions, just hang out and we can talk. And yes, Ron, I will get you a workbook. I'm not sure how that didn't get to you, but we'll make sure. And then if anyone else missed the materials, please let us know. We had some funky things happening with Google Forms, so.
This was fabulous. I learned so much.
Yay.
Yeah, thank you both for inviting us. You kept